Okay, that's the cue. Awesome. So I'm gonna go ahead and get started here. It looks like it's just after 6. Hello everyone. Welcome to the 11th annual Okanagan Embrace Aging Month. Thanks for joining us today on a beautiful sunny evening here in Kelowna. My name is Sean Jeffrey, and I am an investment specialist with Interior Savings in our wealth management department. Essentially, what I do, my role is I'm a certified mutual funds advisor and responsible investment specialist. I deal really closely with our members when it comes to helping them make informed financial decisions, providing guidance on investment opportunities and strategies tailored to their individual goals and risks. So this can look like finding a way to save up for a new property, retirement planning, even estate planning, and as well as taxation. However, today I'm honored to help moderate this amazing event. So before we get started, I would like to respectfully acknowledge that Interior Savings is situated on the traditional and ancestral unceded territory of the Okanagan Syilx Nation. I would also like to acknowledge that you are joining us today from many places near and far, and acknowledge the traditional owners and caretakers of those lands. Embrace Aging is also co-hosted by the Institute for Healthy Living and Chronic Disease Prevention at UBC Okanagan. Interior Savings and Interior Health have partnered together for this. So UBC Okanagan has joined the global network of age-friendly universities, formalizing its pledge to make UBCO more accessible, integrational, and committed to research programs that are informed by the needs of our aging society. If you would like to know more about the Age-Friendly University Initiative, or if you have suggestions for us or would like to get involved, please contact the Aging in Place Research Cluster. Now, Embrace Aging Month was launched already 11 years ago, and it's to celebrate and raise awareness about positive aging, and has once again organized a number of educational opportunities and events during the month of March. These sessions are designed for everyone, young and old alike, and focus on a variety of topics related to healthy aging and ways to improve quality of life among seniors and also family caretakers. So our goal is really to inspire everyone to, just embrace aging. Now there's a closed captioning box that can be moved to your preferred place by clicking and dragging it to where you would like. To turn closed captioning off, select the hide caption button on the menu bar. If you want to type questions, you can type questions or comments in the chat box during the presentation, and there will be a time at the end where we will go through and answer as many of those questions as we can. So today's session is all about estate planning essentials and really just what you need to know. We're joined by two great speakers today. Our speakers that we have with us are Dylan Switzer. So Dylan Switzer is the managing partner of FH&P Lawyers, LLP, a full-service law firm serving clients in the Okanagan and beyond since 1908. Dylan's practice is devoted to estate planning, estate administration, and business law. And his clients include individuals, family businesses, financial institutions, and trust companies. Dylan has been in the Okanagan since 2005 and really enjoys the blend of work and recreation the area offers. Our other speaker today is Shayden Stewart. Shayden is an estate planning specialist with Interior Savings Wealth Management team. He's worked with the credit union space for 10 years, 5 of which are at Interior Savings. He collaborates with individuals, families, and business owners with the creation and implementation of their estate planning, investment, and insurance needs. Alrighty, so I'm going to stop sharing here. There we go. So today's agenda is some sort of like a panel of questions that were submitted in advance. So we will be putting Shayden and Dylan on the spot, and I will basically just be peppering them with questions. Now, again, feel free to put more into the chat, and we can pepper them some more with your guys' questions at the end. But that being said, we could kind of get started and let the peppering begin. Awesome. So Shayden, my first question is going to be directed at you. And really it's, for someone who is feeling a bit overwhelmed with the whole estate planning process, right? It's definitely not an easy thing to, begin. So, in your opinion, where is a good spot for people to begin the process?
Yeah, absolutely. Thanks, Sean. Thanks for the great introductions as well, too. So estate planning, it can be as big as you want it to be. It can be overwhelming, absolutely. I think for me and the majority of people, I would say let's just take one piece at a time. The first thing is just write things down. What do you want to happen with your estate when you pass on? What do you want? Uh, who do you want to receive your assets? Is it your investments or property or that kind of thing? And another big piece when it comes to estate planning is keeping the dialogue open between yourself, your loved ones, and making your intentions clear, and with those around you who are going to be either benefiting or a part of your estate, whether that be the executor or that kind of thing. Again, one thing at a time is the easiest way to tackle most things in life. When you have, how you eat an elephant one bite at a time. So first and foremost, just write it down. Make a plan. Talk with everybody who needs to be involved, including your attorney, your notary, your investment advisors, and let them know what you want to happen, for sure.
Awesome. Thanks, Shayden. That's really good to know. So Dylan, next question is for you. Now that we kind of know, where to begin, what should a basic and estate plan actually include?
Yeah, great. Thanks, Sean. Again, yeah, thanks for the intro there as well. So there's sort of two phases to our estate planning. There's what we can do in life, and what applies to us while we're alive, and then after we're gone. So really, three basic documents cover off what most people need. So for death, we have the will, of course. So part of that's what Shayden referred to. That's what allows us to appoint somebody to make decisions for us after we've died and to carry out our wishes as far as our distribution. There are two pretty important documents that we'll talk a little bit throughout this evening while we're alive, but maybe physically or mentally incapacitated such that we can't look after our affairs. So that's the power of attorney, which most people should be familiar with. So that allows somebody you trust, your attorney, not a lawyer, but your attorney that you've appointed, to look after everything that's not healthcare related. So business, property, money, paying bills, taxes, things like that. And then we have a document, the representation agreement for healthcare. And that's, again, if we can't make decisions about our healthcare and end of life ourselves, it allows us to appoint people that we trust to honor our wishes and gives them some direction as well. So that's if you have those three things, for most people, you're in pretty good shape.
Awesome. Thanks, Dylan. So this is kind of leading me into my next question here, and I'm sure it's something we're all kind of thinking in the back of our head is, what would happen if someone did pass away without setting up a will?
So, me. Okay. So I was looking at the question. I was getting ahead of myself in the chat there. So, yeah, it's one of those challenging situations that there is a solution for. You can apply for letters of administration, but one of the things that happens is you lose control over a couple important things. So first of all, you do lose control over who the decision maker for you is to carry out what they're, the financial administration of your estate. So that that's not usually the end of the world, because usually the person who comes forward does generally want to do well by you. More alarmingly, though, is the distribution. So in your will, you within certain legal parameters have the right to distribute your estate generally how you want. If you die without a will, there's a government chart, table of consanguinity that sets out where your stuff goes, and that is not always what everybody wants, and it can lead to, in the saddest cases, it can lead to some pretty unfair circumstances where you have a spouse and children, because effectively what it does is it gives what's called a preferential share to the spouse at the beginning, and then divides everything else equally between the children and the spouse. So it can create some situations with young families where you have maybe kids that are underage taking nearly half of the estate, which isn't very fair to the spouse. And then later in life, it can create a situation where we have maybe a financially dependent spouse ends up losing half of the estate they were expecting for their retirement to kids, maybe of theirs, but maybe stepchildren as well. So it is one of those opportunities in the will to get around a few of those negative impacts.
Right. Awesome. Thanks, Dylan. So long story short, set up a will. Don't leave it off. Shayden, my next question is directed towards you. Sometimes people will name their kids as their executors, thinking, that they're bestowing an honor upon them. What are your thoughts on this?
Yeah, good question. If I don't know if everybody thinks that's that way or not, but it's a job. It's not something to be taken lightly, and sometimes the person who you appoint as your executor is just not up to it. They just don't have the knowledge, the time, the ability to gather everything that they need. Maybe they're out of province or country, that kind of thing. It can be a burden, flat out, for some people. If anybody who is listening to this call has been an executor before, it's not typically a simple process. It's straightforward. There's steps to be taken, but it's not as easy as and done. What are the alternatives? Like, what do you do in that case? You now are thinking, oh, I don't want to name that person as an executor. Well, there are other options available, such as naming a corporate executor, naming a company. So one of the referral sources that Interior Savings uses is called Truvera Trust. So essentially, you name this organization, Truvera, to act as the executor for your estate, and they do everything, taking the family dynamic away from it. And essentially you're hiring them, so they do take a portion of or their fees for the administration, but what it can do is just take away the potential for disagreements, having a third party deal with everything. So personally, I a couple of years ago gave my parents for Christmas a meeting with the lawyer to do their wills and power of attorney and stuff. And through discussion, they decided that neither my brother or myself would benefit necessarily from acting as an executor. So to simplify their process, they have hired a third party to act as the executor for their estate. And they did this because my family dynamic is quite different between my brother and I. He's a welder, he works in the trades. I'm in finance, and I deal with these kinds of things a lot. So there may be a bit of, is he doing the right thing? Is it, they just didn't want my brother to feel like I would ever take advantage, not that I would, as acting as an executor, or to put him in a situation where somebody could do it more efficiently or better. So just taking that whole piece away from it, adding that third party in, and just streamline the process for their specific situation. And that's the intention going forward.
Thanks, Shayden. So just to kind of build on top of this, you mentioned, it's no easy task assigning an executor. So What would be some things that we can do to make the process easier in advance for our executor?
Yeah, absolutely. I think planning is the biggest piece there. Create a plan, whatever that looks like for you, for your situation. We already kind of covered the wills, power of attorney, representation agreement. All of those are very important pieces to your plan. Another thing sometimes people think about is the idea of prepaying their funeral. Purchasing plots. If you intend to go into the ground, you have the opportunity to pre-purchase your plots. And that can be done with private funeral homes, with the city, depending on where you are, or the township. And sometimes with the funeral homes, what you can actually do is prepay your funeral. So while you're living, you can structure an agreement with that funeral home to prepay. You choose your casket, you choose your flower arrangements, all of those things. You work it into your budget while you're living. So there is something in place for the inevitable time you pass away. Somebody else does not have to take on the burden of choosing, of dealing with all of that, and it's already structured.
Awesome. Great. Yeah, thanks, Shayden. So Dylan, I'm going to direct this towards you now, just for more of a legal point of view. With a legal point of view, what should someone consider, when selecting their executor?
Yeah, thanks. I'll try not to reiterate too much of what Shayden said, because some of it does overlap, and I don't disagree with what he's saying. I frequently have, usually parents come in and say they want to, name, both of their kids or all three of their kids co-executors, because they don't want to hurt somebody's feelings about, having them as an alternate. To Shayden's point, yeah, it's there might be that dynamic, and I'm not trying to make light of, that fair consideration, but at the same time, it isn't really a favor, that you're bestowing on somebody. It is a job. And so, what I tell my clients is, for most people, when I'm picking my executor, trust is the number one factor. You want people that you trust to follow your wishes, that are diligent, that are willing to ask questions and get help. Sure, sometimes sophistication, if you have people, that have been through this stuff before, that's nice. But honestly, if you trust somebody and they're going to ask the right questions, sophistication is secondary for most people. Yeah, sure, some people that have complex business structures, maybe need a bit of extra help there, but for the most part, pick somebody you trust that's reliable, prudent. A couple of things to watch for. No U.S. residents, please. The general rule is that if you have a U.S. resident executor, all of a sudden your estate's going to get taxed in the U.S. if they're resident of the U.S. And that can be a very large percentage of money. So, that's one more factor when you're trying to make your decision. Yeah, no U.S. residents. And, similar to what I just said, I don't love it when people appoint multiple executors at the same time. I like to have one person in charge. If they can't or won't do it for whatever reason, have a backup and another backup if you need it. And then just briefly, to echo what Shayden said, if you legitimately don't have people in your life that you either trust or you don't trust one of your wishes or work practically together, there are third parties out there like Trubera and a couple others that can step in and be appointed to be a third party. I'm sure we'll get to the questions later. There is a question about typical costs for hiring a third party in the chat, and I can speak to that later as well and compare that against maybe the usual fee.
Great, thanks, Dylan. So Shayden, personally, I've actually held lots of meetings with clients where it's come up that their main priority is to find ways to avoid their funds going to probate. So aside from the joint accounts and setting up trusts, what are some other ways or strategies to help avoid probate?
Yeah, absolutely. There are a few different ways. I wouldn't make it a goal to avoid probate as your only goal when it comes to estate planning. But there's definitely ways to mitigate that for sure. I'm a believer in, if you have the means, it's definitely nice to give with a warm hand than a cold one. So you can gift to your beneficiaries, loved ones, charities while you're alive, if you have the means, absolutely. What that's going to do is just deplete your estate. You won't have as much in there, so there won't be as much tax when it comes to probate. Another thing you can do is with your investments, look at specific types of investments. So segregated funds, for example, are a really unique product in the sense that you can name direct beneficiaries on non-registered money. So anything that's outside of your tax-free savings, RSP, RIF, those kinds of things, you can name direct beneficiaries. So what that'll do is just bypass the probate and go directly to them.
And Shayden, if you don't mind, do you mind giving a little explanation as to what probate is?
Yeah, so probate is well, maybe Dylan's better to explain it. I mean, you
Yeah, sure. Or Dylan, yeah.
Yeah, I'm happy to, sure. So yeah, no, and I see that question in the chat, and that's a great point. So probate is sort of the legal stamp that a court would give on a will or an estate to make sure that the court is satisfied that the will, if there is a will, is the final true intention of the party, and there's not more recent wills or something that challenges the validity of the will. And until it goes through that court process, even though you've named an executor, that executor doesn't have legal authority to carry out the steps like sell a property, collapse investments, sell investments, pay beneficiaries, pay creditors. You only get that after the court signs off on you and in the process. That process does take a while, and we can talk about the timelines later in the Q&A. And that is also the court's mechanism to attract what's called a probate fee. So it's basically a death tax in BC. It's relatively expensive by Canadian standards, but much cheaper than the US. Having said that, it is slightly under 1.4%. So the first $25,000 of wealth has no probate fee attached. From 25,000 to 50,000, it's 1.1% on the tax. Anything above 50,000 is 1.4%. So basic math, I just tell people 1.4%. So part of, I'll hand it back to Shayden here in a second, but there are some mechanisms that we can carry out as estate planners and financial advisors to minimize that probate fee. But I always ask my clients to be mindful about how much complexity they want to bring into their life to avoid probate, because I've certainly had clients that are convinced they want to spend more money on me to fix avoiding probate than the probate savings actually would be, and that's just throwing good money after bad. So there are, however, some tools that Shayden has mentioned there. We'll continue to mention that that can bring that down or eliminate the need.
Yeah, and I think we can talk a little bit more about the segregated funds in itself as a tool. I'll share my screen here just so we can kind of go through what that looks like. Bear with me for a quick second here. So what are segregated funds? So they're a type of investment offered by an insurance company. They are a combination of investments and insurance. They are unique in the marketplace as they have to be sold by somebody who is insurance licensed. So not every financial planner does have their insurance licenses and able to offer those kinds of products. They come with guarantees. So there's lots of different types of contracts out there for segregated funds. But some of the big or most important details of it is that there's a principal guarantee, typically between 75 or 100% of what you initially put in the investment. So if the markets, for example, the stock market had crashed and then you passed away, your $100,000 investment is now worth $50,000. Well, your beneficiaries are still going to be guaranteed 75 or 100 out of that. So those guarantees are attractive, definitely, for the right person. The contracts do have a maturity date, 15 years typically, or age 105 for some companies. Each company is different, but they are offered throughout the Canadian marketplace. All the giant institutions out there typically have their own segregated funds. Bank of Montreal, RBC, there's plenty. I won't go through all of that, but I typically deal with a few companies because I really enjoy their products. They have some unique things in the marketplace, like inflation protection as well too. So so that's the thing, that if you're interested in discussing a little bit more about how those products work, we can definitely get into that. Segregated funds are typically, you may have heard of mutual funds before. So it's essentially like a basket of investments that different investors put their money into. You could be, they typically hold equities and fixed income, so stocks and bonds. And those are managed from either the insurance company portfolio managers or different portfolio managers on the back ends, and they have teams and teams of advisors and researchers to make sure that the internal day-to-day trading, getting rid of this investment, getting rid of that investment, buying this, reflects what the mandate is. If you're searching for long-term growth or protection, income side of things, lots of different avenues you can look at and adjust the investments themselves to fit your risk tolerance. And how can seg funds be beneficial? So we talked about the principal protection for sure. If your investments don't perform well, there is some guarantee that your beneficiaries will receive at least 75% or 100%, which you initially put in. There is the beneficiary designation. That's the important thing that I think we're looking at today too, is we talk about the non-registered money that you may have in outside of your RSP, tax-free, that kind of thing. You name direct beneficiaries. So if you want that to go to say you have a blended family and you want it to go to a specific person, you can do that. It bypasses the whole probate aspect, and it's typically quite a fast turnaround once all of the requirements are met, like a death certificate and whatever else the insurance company needs for paperwork. The turnaround to get those beneficiaries their money is 5 business days typically. So it can be very quick for sure. And again, avoiding probate. So we saves time, saves costs. The management of the segregated funds there are costs associated with that, just like any mutual fund, for example, would have a management expense ratio. It's typically built right into the investment. Same thing on the seg fund side.
Awesome. Thanks,
Thanks.
Shayden. That was that was some good info there. So sticking with the investment train, how can someone make sure that their investment accounts transfer quickly to their heirs or beneficiaries? You mentioned seg funds and naming the beneficiaries. Are there any other strategies there?
Insurance contracts, definitely. So life insurance, that's another way you can transfer your assets, and life insurance payout, and you can transfer that. I can't think of any other ways to transfer your assets at the moment.
Okay. Yeah. No worries. No worries. That was I feel like you already kind of talked on that there. So great. Dylan, I have a 2-part question for you here. Now, this is something that a lot of people are probably thinking, and it's important to discuss as well. And it's, what should someone do if their child, let's just say, is not that good with money, or they may have an addiction or some other problem that, financially worries their parents. And then the second part is, if they decide they don't want to leave a full inheritance to that child, what options do they have?
Yeah, so generally we have freedom in our estate plan to leave things to who we want. However, the courts do have the ability under our legislation to vary our will if they don't think we're fair, just, and equitable to our spouse and to our kids. So, the few things I'm going to speak about here need to be overlaid by the chance that maybe the beneficiary we're excluding or that we're actually trying to protect is unhappy with what's going on. So it ends up being a bit more of a nuanced conversation. Having said that, when we have kids that are, bad with money, maybe on the verge of divorce, maybe have, a condition, a medical condition or addiction issue that just, really means that the money's not going to go to, necessarily where we would want as the people giving it to our children. We can do certain things in our will and in trusts in advance, but they both involve trusts. So for example, if you had two kids, and one child, had some challenges, we could choose to put that child's funds in a trust. Now, I typically like what are called fully discretionary trusts. Those allow the executor or trustee to pick and choose how fast or how slow money comes out. So if the child's doing really well, we can advance more money on certain conditions or not. If the child is going through a rough patch or maybe a separation, we can choose to turn the taps completely off on it. So we can do that, and that can be relatively indefinite within the confines of the will. Similarly, we do it with minors all the time. We do it with middle-aged people sometimes. Is we can specify when certain funds are paid out of that trust over time. So we can say, listen, if it's for education, if it's for health, sure, we can get, with the trustee's permission, we can get the money out. But for the most part, maybe we're going to wait until a kid hits 25 or 30 or 35, just to make sure too much of it isn't frittered away in the early days. Now, so that's good. So if you do have some of those concerns in your life, that is something you can work through with your lawyer, and there are a couple good plans there. But for whatever reason, but commonly, lots of us have relationships with our kids that motivate us not to want to give them much, and that's a bit more challenging in BC, because if we're just not going to give anything to them outright, they can bring an application to vary the will for perceived or actual unfairness. And there's a whole bunch of criteria that we could talk about in questions later, setting, but what a court might do. Having said that, the chance there are the chance that our will does get set aside. So if we really want to do that, and we're over 65, there's again some trust planning that we can do to again pull assets out of our estate in order to keep the will from being varied. Because if the asset's not going to go through a will, then you can't vary the will to get more access. But that is there are some tools out there that your estate planner can help you work through.
Right. Yeah. Thanks, Dylan. That's some good info there. Shayden, there's a lot of people who are, worried about potentially outliving their savings, right? I think that's a common fear for many of us. Now, what can people do to help ensure that this doesn't happen?
Yeah, it's a great question for sure. It's on a lot of people's minds now more than ever. People aren't retiring; they need to keep working. Absolutely. One thing that you can do is look at annuitizing your money. Whatever you do have for savings, if you have savings, you can work with an insurance company to offer what's called an annuity. How that works is that essentially you give them your money and they pay you back monthly. And that can be set up and structured in many different ways for a specific length of time, for say 10, 20, 30 years, for the rest of your life. It can be based off of many different factors, and how much you get monthly is calculated based on your age and all of those other components on, how long do you need it for, want it for, that kind of thing. So there's not one box for every person. It's completely different for everybody, really. So that's one avenue you can look at to stretch your money as long as possible. Know what you're going to have to work with, build a budget around what you have.
Great points there, Shayden. Appreciate that. Um, Dylan, I want to ask you, there's a lot of people with wills, and they have a beneficiary that might be disabled. Are there things that they can do to better look after these beneficiaries with disabilities?
So to frame that question a little bit, it's important to keep in mind that if you're a person with a disability in British Columbia, there might be government assistance that comes to you as that individual, and that it varies, but it's usually between $1,000 and $1,800 a month you might get by way of government support. Now, if you receive a windfall of cash, be it an inheritance or a gift, that can actually cause the province to turn off the taps on the benefits that you applied for and you're owed. So you can preserve your government benefits and receive an inheritance if either in life or in the will, a trust is set up that we call a fully discretionary disability trust that allows the money that would otherwise go to that disabled beneficiary to be paid into the trust, so it doesn't interfere with the benefits. And then your trustee can use that pot of money to buy certain assets, to provide walking around cash and things like that. So the document's a bit more complex than I just made it sound, but there is a tool. So if you have somebody in your life that's has a disability, or somebody just make sure that their estate planning matches in a way that'll preserve that benefit for them.
And Dylan, just taking a look at the chat box there, would you be able to just quickly explain what a trust is?
Yeah. So and I see there's another question about persons with disability. I can talk a little bit about that perhaps as well, because it is related, because there is a financial threshold. So the first bit about a trust. So there's two types of trusts. Well, there's more than that, but there's two main buckets of trusts. Some of them are what we call inter vivos trusts, just a little Latin for your Tuesday night. That means it's a trust you establish in life, and then there's what we call testamentary trusts that we establish in your will. And just think of a trust sort of like a company or a contract. It's a separate legal entity from the person that's administered by somebody to the benefit of other people. And so you would appoint somebody, usually somebody different than the beneficiary, to manage money that's held by that trust. And that trust is a taxpayer, and it has to do filings, that can have accounts with people like Sean and Shayden, and then it can pay out to the beneficiary on the terms of the trust. So just think of it as a separate entity. Okay, so there's that. Now, there's some stuff in the chat there, and it ends up being a bit of a government policy thing. So at the start of my career, we did these disability trusts quite frequently, because the government threshold for interfering with people's benefits in BC, and it's different types of benefits. So it is benefits under BC, but it can also be in certain programs and pensions like Veterans Affairs and things like that in certain ways as well, for certain programs they have. So it used to be a $50,000 threshold. Now it's a $100,000 threshold. So now more and more you can get more money to persons with disabilities without needing a trust and without triggering the need for it. And practically, the government hasn't always enforced it. So typically what we do, if we have a person in our group or in our client list that has a person with a beneficiary, we usually get their contact at the ministry and their social worker, and then we work through to chat through how much inheritance we might receive and when. And if we can avoid having to do a trust, we absolutely do, if we think that there's a reasonable way to avoid it, short of going through that effort.
Oh, sorry, I was on mute there. Awesome, thanks, Dylan. Just taking a look at the time here, I got a couple more questions here for you, Shayden. Next question would be, for someone who has a strong belief in charitable giving, how can they incorporate this into their estate plan?
Yeah, good question. There's a few different programs out there, Canada Gives being one of them. If you have a large sum of money and you want to set up like an endowment, that doesn't sit with a lot of people, myself included, where I'm able to set up an endowment that I'd love to. There is programs available out there. Canada gives one of them. Fidelity has another one as well too. But you can look at charitable giving in a couple different ways. Maybe you want to have your name on the side of the building. You can maybe use a life insurance policy to do that. Maybe you don't have the $1 million at the moment, but you're able to make your regular monthly payments for a life insurance contract. You can name really anybody or any company as a beneficiary for that life insurance policy. So you could take out a policy and give the proceeds to the SPCA or the church or whatever is important to you at that time. You can also, again, kind of spoke about it a little bit earlier, but gifting, you can gift others investments themselves. Actually, we can do what's called a deed of gift within our wealth management side to move an investment directly from yourself to somebody else, or to another charity or to a charity or something like that. There's a few different things that you can look at for sure while you're alive for charitable giving or planning for after you pass. On that, again, naming beneficiaries is great. Putting it in the will is another way that you can think about charitable giving.
Great, thanks, Shayden. So you kind of mentioned insurance at one point there. Many people would like to leave an insurance policy to their beneficiaries, but sometimes they may have health history or issues regarding their health. What options are there for these individuals?
Yeah, absolutely. As time goes on, more and more options become available. Once upon a time, it was like, oh, I have diabetes, can't get insurance, or I've had a heart attack in the past, hard stop, cannot get insurance. Some companies out there have created a product. It's called Simplified Issue. So it doesn't take into account the same type of medical underwriting, and that is jargon. So medical underwriting is essentially taking your blood, urine, vitals, all of that, and having somebody review it and assessing the risk that you'll die from a heart attack or your high blood pressure or that kind of thing. The simplified issue products don't do that to the same degree. Typically, it's you answer about 15, 20 questions, and it'll be a yes or a no, you're approved. There aren't a ton of companies out there that offer these kinds of things, but Industrial Alliance being one of them, Canada Protection Plan, who is actually owned by Foresters. They've got a huge marketing on television, the campaign going, you may see, will approve anybody. Absolutely, they will. It's a matter of, can you afford the coverage? And so when we're talking life insurance, obviously the best time to buy life insurance is when you're young and when you're healthy. And if that's not the case for your scenario, maybe you weren't able to do it when you were young, you didn't have the cash flow, that's understandable. Now something's happened. There's still options out there for sure.
Awesome. Great. Thanks, Shayden. Just keeping cognizant of the time here, guys. I'm gonna fire one more at Dylan. Dylan, so my question is, what happens if I become mentally incapacitated and I don't have a power of attorney or any representation agreement for healthcare?
Okay, so I'll start with the health one, the representation agreement for healthcare. So for people that are fortunate enough to have either a spouse or a parent or an adult child that they trust, actually, believe it or not, you don't necessarily need the representation agreement for healthcare, because there's again a government chart that directs who might make those decisions for you if you can't. Of course, if you're unhappy with the person that would be next in line, whether that is a worry that your adult children might infight, then it's important to have the document. The power of attorney is the tougher one, though, because there is no government chart that allows somebody to step into your shoes for finance, for property, for all money things, bills, if you don't have somebody appointed. So the mechanism to fix it, and there is a mechanism to fix it, is applying to the court for something called a committeeship. And And it's one of those situations where it's time consuming, it's expensive. You know, usually we tell our clients before you get the public guardian trustee to sign off the doctor's letters, you know, it's 4 to 6 months, and definitely relatively expensive. So, you know, power of attorney is relatively cheap insurance to avoid having to go through that process.
Right. Thanks so much, Dylan. So I think just looking at the time, I think we should maybe open up some time for the chat questions. Before we do that, was there anything else that either of you wanted to share regarding estate planning?
For me, actually, I just want to comment. There actually is a whole host of really good questions. So anything else that I want to add, I think is going to probably come out of the sidebar there personally.
Yeah, I'll echo that too.
Cool. Awesome. So yeah, so I'm gonna ask you some here, and the first one, I think might be directed a little bit more towards you, Dylan. It says, regarding choosing an executor, is it recommended to choose someone that lives in the same province?
Yeah, so again, as long as it's not the US, I'd rather have somebody in Newfoundland than in Washington State. So, all else being equal, if you can have somebody else in BC or in your same town, it'll make their life a little bit easier as far as doing the job. So yeah, half points for proximity. Having said that, I deal with executors literally every day from all corners of Canada, and there's maybe slightly more delayed and otherwise slow process, and we might have to do a Zoom meeting or two instead of face to face. But yeah, pick the right person as your priority. Don't worry as much about what they are.
Awesome. Shayden, I think this next question will be directed towards you. Dylan, feel free to chime in if you want. And it's saying, what would happen if you were to pass on and there was still money left over in an annuity?
Yeah, that's a good question. So it's gonna matter on how it was structured to begin with. So there's something called the guarantee period, where say it was 10 years, the guarantee period, you're guaranteed to receive payments for at least 10 years. Should you die in year 5, your beneficiary would receive the remainder as a lump sum payment, typically is how that would work. So if there was essentially, you got to take the mindset that you don't have this money anymore. There is not necessarily any money left in the annuity at all. It's the risk that you take by setting up an annuity without a guarantee period is that if you were to pass away the next day, all of that money sits at the insurance company, and there's nothing coming back to you.
And yeah, Dylan, I have one here for you. And the question is, if your child divorces, does the ex get half of the trust money?
I was worried you were going to ask that one. That one's relatively tough. So it's actually not that tough, but it's a bit tough to explain. So as a general rule, if the funds are still in trust, your ex-in-law is not going to be able to get that money if the trust is fully discretionary. So remember, I said discretionary early. That allows the trustee to pay out as much or as little at any given time. That's the key part, because if the trustee can just say no, then the ex-spouse doesn't get it. But if that trust says, I'm going to leave money behind for my daughter, and I'm going to give her $2,000 a month until the trust is depleted or she passes away, then the ex-spouse can get their hands on sort of a prorated basis of that payment coming out in the family law dispute. So it's important that the trust is discretionary. It's also important to note that once the money leaves the trust and say goes into a child's hands and then they get divorced, that money's gone. That is now part of the family estate, especially if it's been used as a family asset. So that money is now fair game for divorce. So that's why if we're worried about that practically, and I do encourage, I know it's uncomfortable, but I do encourage transparent conversations between parents and children in these examples. If there is problem or perceived problem with the marriage, you guys can plan to the benefit of your child, and they might be very okay with a discretionary trust to keep that asset safe.
Great, thanks, Dylan. Shayden, what about mutual funds? Do they always go through the estate and are they always subject to probate taxes?
Yes. Mutual funds specifically in a non-registered account. That is again not your tax-free RSP, first-time home buyers or RIF accounts. If they are in a cash account, non-registered, it does become part of your estate, and it will be part of the probate declaration.
Awesome, thanks. Either one of you guys can answer this next question, and it's about timeline. Question is there a timeline in which an estate must be closed by?
Dylan, I'm going to refer to you.
Yeah, maybe I'll take a crack at that. So
Yeah.
first of all, I'm going to say it's very slow. Some of it's deliberately slow because the courts want to make sure that creditors have a chance to come forward, make sure that everybody's had an opportunity to make sure the right will is being proved to the court. So it's a slow process. And then you add in lawyers and the CRA and it becomes slower from time to time. An executor does have a duty to be reasonably prudent in administering an estate. And there's this old kind of concept of law that's loosely enforced, the concept of what's called the executor's year. So the expectation is that the executor should be taking meaningful steps to advance the estate administration process within a year of the death of somebody. It becomes a little bit subjective, but yes, if an executor is being too slow, the beneficiaries can talk to a lawyer about removing that executor.
I have a quick story around something like that. My mom was recently named a beneficiary from her deceased uncle alongside 18 other people. And it was almost a year before they were even able to contact all of the beneficiaries to let them know. They're now approaching year 3 of the executors working through this, and it's a process for sure. It can take some time. So depending on the estate, how you name your will, whatever you do in there. Yeah.
I usually tell clients that, if all goes well and if the financial institutions get, asset values, if there's nothing too weird, your lawyer, depending on their court jurisdiction, should be able to get you probate in sort of 4 to 6 months if you're doing your part as the executor. Now that just gets you the court order, the stamp that allows you to do things like sell assets, liquidate investments, turn them into cash and pay them out. And there's usually some accounting advice. So really, if all's going well, call it probate in 4-ish months, some money out to the beneficiaries in 6 to 9 months, closed off from the CRA's perspective, where the CRA promises not to reassess the taxes of the deceased. That's probably, best case scenario, 14 to 18 months after death. So that's best case. So you throw in a couple of wrinkles or punches and it can go on for some time.
Or have a segregated fund for some of your investments and buy business days. Definitely some advantages there.
Awesome.
It's the right call for everybody. Time and place. It's individualistic. It's to your situation.
Right.
I'm going to respond to this question in the chat here. What if mutual funds are in a registered account? Will it still go through the estate, even if the beneficiary is named? No, it won't. It is a named beneficiary and it will go to that person.
Yeah, thanks, Shayden. I have another question here. This might take us to the end. It's a bit of a in-depth one, but either of you guys can feel free to jump in. Dylan, it might be more directed to you. And it's saying, for someone who has little assets, but a large amount of debt, let's say credit card debt, they were told not to have a will because their children could inherit their debt. Is this true? And is it also the same for a power of attorney?
Yeah, no, good question, and something that we do deal with a fair bit. No, they're in British Columbia and Canada, there's no automatic circumstances where the debt goes from one generation to the next. So whether there's a will or not, it's not going to make it to the children. Now, of course, if there's assets there and there's a lot of debt there, the debt will offset the assets. So the beneficiaries obviously won't get as much, but at the same time, if there's more debt than assets, it won't go through. Having said that, the person who could be liable for that debt, pretty rarely, and they can buy insurance to protect themselves, is the executor. So if you name an executor and you end up with what's called an insolvent estate, if that executor makes a mistake and pays out creditors in the wrong order of priority, say pays a credit card company before they pay the CRA, for example, that executor can become personally liable through that error. So one of the things that we do if we have an estate that we think is going to be insolvent, once we ask the executor to bring in all the information they can, we try to figure out where their assets and debts are. If we think that it's going to be insolvent, we ask the executor to make a tough decision about whether they want to administer the estate at all. And frequently we advise them not to, because that keeps the risk at its simplest. And instead of having them work for a bunch of creditors, we just tell them to not do it. But sometimes there's an asset that needs to move, like a piece of real estate that should get moved out of the estate, even if it's not as valuable as the debt. So you should work through the process, but you just have to be careful. And while I don't think lawyers are always necessary on estate files, I'd strongly recommend you get some legal advice if you are considering administering an estate for somebody who might be insolvent. But yeah, don't worry, your kids aren't going to get your debt. It dies with you.
Awesome. Thanks, Dylan. Just taking a look at the time here. We might have time for one more question here. Let me just see. So I have a question here that says, what happens if there is no family members with the no will scenario?
Yeah. So in my career, I've only seen a couple estates end up where the assets go to the government, but technically it can happen. So, and I please don't want to quiz, and I know this is recorded, but I don't want to be held to it. So there is this chart that does specify where your assets go if you don't have it. So spouse first, then kids, then grandkids, and parents, then siblings, then nieces and nephews, second cousins, and so on. And it goes on for a very, very, very long time. And if that fourth cousin shows up, that fourth cousin is going to get those assets. If after diligent effort by whoever comes forward to administer estate, it literally can't be done, it will what's called escheat to the province, and it will become a provincial asset. Doesn't happen very often, but yeah, if you don't have anybody in your family and you do have assets, ironically, it's actually extra important for you to do a will, whether it's charity or friends or whatnot, because then you will lose all control of your estate on your death if you don't have a plan for it.
Great. Awesome. Thanks, Dylan. Well, guys, I think that's all the time we have for questions. So thank you both. Thanks, Shayden and Dylan. And honestly, thanks everyone for attending this webinar today. We do encourage you to attend other events scheduled for Embrace Aging Month. So if you are interested in that, please visit the website OkanaganEmbraceAging.com for all events and registration. We look forward to growing this event in the Okanagan and encourage anyone interested in supporting in the future to please contact us. Contact information is available on the website OkanaganEmbraceAging.com. You will receive an email with a link to an online evaluation form. And so we welcome everyone's feedback and suggestions for any planning events in the future. Awesome, guys. So thanks so much. And Dylan, Shayden, thank you so much for your time today.
Thanks for hosting, Sean. Thank you everybody for listening.